All right, everybody. Um, Good afternoon. This is a meeting of the Non-Energy Utilities Subcommittee of the Environment and Transportation Committee. And thank you all for joining. Today, we're going to take up two bills. And this is mainly going to be a work session. The first bill we're going to look at is House Bill 480. I believe that you were sent some last minute amendments, one on this bill and one on the other bill we're going to consider, which is 950. Um, so let's take up 480. So basically, there is an extensive amendment to this bill that really substitutes the bill. And I'm going to ask Steve Ross of our staff if he could share his screen. Can you do that, Steve? Well, before we
I
do that,
can.
yeah, okay. And
Just
let's
give me a
just
minute.
go quickly through the reprint, okay? And if you could highlight what this bill does, and then we'll flag, you and I talked about some areas that we wanted to kind of flag. We'll do that after you go through the bill kind of in general, okay?
Sure, just give me one sec to get a
Sure.
document that I can share.
So while he's doing that, let me just say that this bill, to refresh your memory, is about deactivation of rideshare operators. So it's to put some guardrails around, put some rules in place about when a transportation network company can deactivate and how they deactivate their rideshare drivers. And it also has a portion that allows for appeal. So when there's a deactivation, there's a mechanism for an appeal. So Steve, are you ready?
I'm ready.
Okay. And
Just give
Dan,
me
make sure he can share and go ahead, my friend.
just give me one sec to actually get it going.
Sure. There we go. Great. I always like it when the technology works.
Yeah, that's nice. Yes.
Okay.
Okay.
So go
So,
ahead, Steve. Go back to the beginning and then kind
sure.
of just, you don't have to go into great detail, just kind of outline for the committee, what the bill looks like now.
Okay. So this is the purpose paragraph, and for an amendment that strikes the bill in its entirety, it's actually not that different than you. It's actually not that different. So basically, what happened is the original bill was struck in its entirety, and it was rewritten. Some things are different, but the main piece is sort of the same, right? I think it's probably just easier to rewrite it rather than go in and make a bunch of changes all throughout the bill. So it's a little easier to see as you're reading the amendment, but it's not necessarily as easy to see the sort of the net changes. But in general, what this doesn't do is change the definition of transportation network company. I believe that was in the bills introduced that had some testimony about it incorporating additional companies. That's not in this. Right now, these are only in here just to describe what a transportation network company is. For that's basically Uber or Lyft. Those are the big ones operating in the state. In this context, transportation network services is what a Uber driver provides, and the driver is called a transportation network operator. Those are the terms of art for purposes of ride share statute. So what this bill did when it came in, but also as amended, is it requires the transportation network company to maintain and apply a written deactivation policy that provides policies and procedures for the deactivation and then an appeal procedure. The amended bill does not involve, sorry, the original bill had a process that went to the Public Service Commission sort of afterwards for resolution. The bill as amended does not. It's all an internal process. So I wanted to mention that. Um, the basics, give me one sec to grab my other document here. The basics of the policy. Basically, it's enforceable as a term of the TNC's contract with the operator. must include a definition of serious misconduct and examples. Has to provide the operator with a reasonable understanding of what constitutes a violation. Describes the procedures and eligibility criteria for reconsideration of the deactivation decision, and that was particularly important at the hearing. And it must be specific enough for an operator to understand what constitutes a violation and how to avoid violating the policy. So that's what all of this language is right here. And there is a general prohibition that a transportation network company may not deactivate an operator for a violation not reasonably understood to be part of the deactivation policy. There are some I would describe it as driver protections in here about what can and when you have just a passenger report, just the passenger saying something, when you can be deactivated. So there's like an additional threshold for some things like that. Again, that was brought up in the testimony by some of the drivers. And down a little bit further, you have, let me see here, make sure. Since it's an amendment, and it's completely rewritten, I was just want to make sure I'm getting it right for you. Okay. The only times it can rely solely on a passenger report is if it's within 14 days of the incident, if it involves a violation of federal or state law, an alleged violation of the company's non-discrimination policy, fraud, or operator road or personal safety. So basically, the higher threshold of infractions, you can rely on just one person's statement to get it to deactivation to occur. This is new. This is a provision about allowing the drivers to collect their pay that they had earned before they are deactivated. You're not paid. You earn money before you are paid. So if you're deactivated, you can get that money up to that time, as long as it wasn't the money you were earning was criminal or fraudulent, I think, basically in nature. So as long as it's not that, then you can collect the money that you earned before being deactivated. And then it sets up an appeals process. If you are deactivated, it sets up a formal appeals process. This is an internal process, not a legal. It's not through a court. It's not through any particular court. It doesn't go through the Public Service Commission. It's sort of an internal process, or with the assistance of a private third party, an appeals process. My understanding is that these are basically consensus amendments. As it stands right here. Now, there was an additional amendment that came in that
from the National Federation of the Blind, right?
Yes.
Yeah, I want to talk about that separately. Okay.
So that's the basics of this. In general, it's pretty similar. The main pieces are the main difference is, in my opinion, is the appeals process, not including Public Service Commission. And we did hear from Public Service Commission that in this current form, it eliminates the fiscal note, which was substantial on the first reader, and that's because there's 175,000 drivers in the state. There's a lot of them, so even a small percentage is a lot of drivers. And then they also provide testimony that there were 6,500 deactivations in a recent year. So there's a lot of these occurring. So the pulling PSC out of that process eliminates the fiscal note.
Yeah.
Okay,
so,
that's what I have.
Yeah, so this sounds like it's like an arbitration procedure for a sort of for an appeal process. That there's a third party. It's not the company that decides. It's a third party that decides. That is a tiebreaker on an appeal, right?
I think it's through the company, but they can get assistance. So the bill as set up allows for assistance of a third party.
Okay.
Is the process here. I'm trying to find it.
Yeah, I saw it in there too.
Okay.
Okay. All right. So, there is the potential for a third party, but you said these are consensus amendments with with the rideshare companies and the sponsor of the bill and the supporters, the advocates for the bill, correct?
That's how it was described to me. Yes.
Okay. Okay, great.
I'm gonna, want me to
Okay,
stop
so
sharing?
yeah, great. Okay, thank you. So
Yeah.
Steve mentioned that there is, we do want to hear from the National Federation for the Blind because as you recall during the hearing, there was a bad connection. And we want to make sure that we hear from their representative who's on this call. But before we do that, I'm going to ask, are there any questions about this bill and the amendments as has been outlined here? Okay, seeing none. Let's move on to the issue raised by the National Federation for the Blind. You should, late in the day, but you should have received this amendment. And this basically, well, Steve, do you want to describe what this amendment does? It basically adds an egregious misconduct class to this to the bill.
Just give me 1 second to review it because we did get it relatively
Yeah,
late.
I apologize for the lateness.
that's okay. So Ronza is on here. Hi, how
I'm
are
here. Hi.
you?
And I hope you can hear me better this time.
Oh, much better. Yes, thank
Okay.
you.
Okay. So in general, this amends, I think it amends the bill as introduced, which had language defining egregious misconduct. The bill as amended does not define it. That is struck from the original bill. It does require sorry, I almost said utilities. Does require the TNCs to define it just outside of the law. But in general, it includes in egregious misconduct discrimination by an operator against a passenger or customer based on disability, including, and there's a couple examples, but not limited to, refusing or canceling a ride due to the presence of a service animal, refusing or canceling a ride due to a passenger's use of a long white cane, walker, wheelchair, scooter, or other mobility aid, harassing, intimidating, or otherwise treating a passenger adversely because of a disability, or violating federal or state disability rights law and the provision of transportation network services. And then that is the definition. And then the teeth of it is if an operator has clearly engaged in egregious misconduct, including disability discrimination, the transportation network company may immediately deactivate the operator. I think that is the basics of the amendment. I think that's the
Yeah.
main part of the amendment.
Yeah, I think that's right. Let me ask a question though, Steve. As I read, there is no other immediate, is there a provision for immediate, uh, like essentially, well, I guess immediate deactivation is sort of the whole bill, but, there's no other exemption for deactivation in the bill, or from the procedure, the appeals procedure, right? There's no other conduct that is exempt from that. In other words, this language to immediately deactivate, that's not really in the bill, right?
I believe it's new. However, they're in the appeal process in the process about sort of the appeals and the notifications. It does imply that because for serious
It does.
misconduct, you
Okay,
can provide notice of why after it occurs.
right. So serious misconduct, um, there is a definition of that in the bill.
I mean, I think if we, and I thought we were looking at the most recent version of the bill, but maybe what we saw wasn't. I don't think we're tied to the word egregious misconduct. If it's
Okay,
part of the definition of serious, that would be fine. But in
okay,
terms of current operations, Uber, Lyft, when they receive a report from um, a passenger who's alleging this type of discrimination, they're supposed to do an immediate deactivation pending investigation. And then if it's it's a suspension for first offense, a permanent deactivation for a second offense. Problem is they're not doing it. And part of the reason why then that's written in their policy. But part of the reason why they're not doing it is because they're saying, well, our drivers, our operators are essentially required to have due process and notice and yada, yada, yada. So even though it's in their policy that that's the procedure, they're not following it for that reason. And so our thought is let's make it clear to everybody in Maryland, this is what's going to happen so we don't have that gray area anymore.
Okay, so two things that I noticed in the bill, and then I want committee members to jump in here if they feel that way too. But two things that I noticed in the bill that maybe could help us with this. One is it does require a deactivation policy. So now we're talking about the requirement for a deactivation policy to be in the law. And then there are stipulations about what that deactivation policy entails. And there is a notion that it includes a definition of serious misconduct, as Steve pointed out. So that's a place where maybe we could address this. And then the second part is there is a provision in the amended bill that says that you can rely, the transportation company may rely solely on a passenger report as the basis for deactivation if, and Steve went over this, the report is submitted within 14 days of occurrence. And then the second one is the report involves an alleged violation of a federal or state law. And clearly, the conduct that you're describing, Ronza, would be in violation of the ADA.
You would think.
Yeah, no, I think it is. I mean,
we think it is.
Yeah,
Whether
I looked
Uber
it
and
up
Lyft think it is.
Yeah, AI says it is. So, so I think that those are two areas where maybe we could address this issue. I would just say that we're in the process of working through this bill. So maybe we can take a look at that and see if we can put some language in there that helps with this situation. If that sounds good to you.
Perfect to me. We're not tied to any particular language or any particular part of it being in the bill, as long as there's something that clarifies, hey, this is your obligation here.
Yeah, I understand that that's a big problem. Because I've heard that anecdotally. I don't know that much about the rideshare operation. I mean, I use rideshare, but I don't know.
Mm-hmm.
But it seems to me that we should, especially the animal issue, the animal issue. So we can discuss this. We can discuss the whole thing, but I'll open this up now. I see Delegate Naraki has his hand raised.
Thank you, Madam Chair. This maybe is for Steve. I'm just trying to wrap my head around where this policy would apply if, since we're talking about Uber or Lyft, one of those companies, say someone starts a ride in Washington, D.C., and then ends up in Montgomery County or Prince George's County or wherever the case might be. Does this then, does it apply where the ride starts? I'm just trying to, because we're talking about moving vehicles.
This is a good question. All right.
Do you understand what I'm trying to ask, Madam Chair?
Yeah, I understand. So I get an Uber in DC.
Yep.
And I go into Montgomery County, and then how does this, if this is not in place, and I don't know what's in place in DC, but
exactly.
Yeah.
Or pick whatever state, Virginia, wherever.
Where the ride starts, or conversely, if I start, let's do it that way. If I start in Maryland, where this is in place,
yes,
then I go to, I ride into DC, or perhaps Virginia, or somewhere, Pennsylvania. We live in a congested area. Then what happens? What if the violation occurs there?
Correct.
Does that, Steve? Do you know, or maybe somebody from rideshare knows? Are there rideshare representatives here?
Madam Chair, you got exactly what I'm trying to wrap my head around that.
I hear you.
Exactly.
Who's here from rideshare, who's representing Uber or Lyft on this call?
Hey, everybody. I don't know if you can hear me. It's Andrew Karwoski. I represent Uber in the DC area. Yeah, I think it's a really good question. I think, the way the bill is drafted, as I read it, it would apply to any operator who's licensed to do trips in the Maryland area. So you have to have a license to do trips in the area. So if you are authorized to do trips in Maryland, you'll have that license, and thus this you. So I think it's less about where the trip starts and begins, and more keyed into where you have the license, and whether you have a license and authority to do trips in Maryland. And I think apply to you even if you do trips in DC or Virginia.
Right.
But okay, Madam Chair, may I ask a follow-up to that then?
Sure, go ahead.
So, operating under what you just said there, so let's say that a trip starts in Maryland, but ultimately ends up in Washington, D.C. The alleged incident that would trigger this, though, happens in Washington, D.C. So does this rule apply at that point, even if the incident has occurred in Washington, D.C., or are we operating under whatever rules might exist in Washington, D.C.? Like, I'm just trying to understand what happens, and then is that person barred from using the app in DC and not Maryland, or vice versa? Like how does that work there?
Well, I'll let Andrew answer, but I think they're deactivated, so that means they can't drive for them.
Is that nationwide? If they're deactivated, is that what that means?
I don't know the answer to that, but I think so. Andrew,
Yeah, that's generally the way it would work under the bill. Yeah, so deactivation is a permanent deactivation, so you'd be permanently.
Yeah, you'd be permanently deactivated.
Okay, thank you. That helps me kind of put this together. Thank you.
Good, thank you. Thank you for the question. Okay, are there any other questions about this or about what we talked about with respect to the Federation for the Blind? Addressing their issue on disability. All right, as I said, we're not going to vote on this today. We'll work on on the possibility of an amendment to address the issue raised by the National Federation for the Blind, and and look to vote on this in a subsequent meeting, maybe even next week, if we can get it into shape. So any other questions about the other amendments we discussed, talked about, or this bill in general before we move on to our other bill that we want to talk about? All right, seeing none, I'm going to move on to HB 950.
Thank you.
Yes, ma'am. Thank you for joining us. I'm going to move on to HB 950. And this bill, to refresh your memory, and you should have gotten this reprint as well as possibly some amendments, standalone amendments that are incorporated in the reprint. Okay. So this bill is about street lighting equipment and municipalities being able to acquire the street lights network, or the street lights, so that they can operate them. And then how does that work, and what's the relationship with the utility after that? Steve, do you want to go over the amendments to this, and then we'll talk about some areas that we need to take a look at here?
Sure. Do you want me to share screen again?
Yes, please.
Okay, just give me a sec to do the same thing. Gotta find a digital copy real quick. I think I have it. Okay.
There we go. Okay.
Okay, so the amendments to this are not particularly substantial in terms of compared to the entire bill. I would still say that the short summary in the original fiscal note is basically correct. So the bill authorizes the local government, subject to specified requirements, which are changed as amended, to submit a request to acquire street lighting equipment, which is also changed via amendment from an electric company at some or all locations within the county or municipality. And then after acquisition, it can convert its street lighting service to a customer-owned street lighting tariff, which is also established under the bill, and enter into an agreement to purchase electricity. If the local government and the electric company fail to agree on the purchase price or conditions of purchase, the local government may acquire the equipment by condemnation at the net book value, subject to specified requirements. The bill takes effect June 1, 2026, so it's an early effective date. So the amendments are not particularly large. So we do define, or the amendment does change the definition of net book value here. There was testimony about this, and I think we'll talk more about this
Yeah, we're going to talk
definition.
more about it.
But
Yeah.
this is a slight change here. To me, this reads similar to what I was seeing in the PSC case about the vintage-based cost, but we'll talk more about that in a few minutes. There was some language change here about changing streetlight service point to secondary tap. I think it mostly is applying the same thing. I think that's doing roughly the same thing. I'm not an electrical engineer. There is a slight change to the definition of street lighting equipment. And most of this is otherwise left alone. It's tough to tell, but this is actually weaving into a much smaller current law. It doesn't look like it. It looks like it's all new language, but it is actually weaving into a current law.
Okay.
And then again, this is related to the net book value and the purchase price, which I believe has been somewhat of a sticking point in this entire
Yeah, we're
history
going to
here.
go back and talk about that.
Yep. And then another change here, which is about who may work on the streetlights, and the bill as amended allows a jurisdiction may contract with an OSHA qualified electrician to install and maintain the street lighting equipment owned by the jurisdiction, and specifies that the electric company, that's the utility, may not require jurisdiction to use the electric company or a certified engineer or other person to install or maintain the equipment unless it involves a break of the connection or reconnection to the secondary tap. So OSHA qualified electrician, that's a workplace safety qualification. It's not an electrician's license. They are
Right.
separate things. One allows you, they're separate regulatory schemes, and depending on the nature of the work you're doing, you need one or the other or both. They're not the same. They're not the same thing. Just want to point that out. I believe that is most of the amendment. Yeah, that's the bulk of the amendments. Compared to the rest of the bill, not a ton of changes. Mostly just tweaking language that is already sort of in there.
Right. So, there were, this bill, was, I was testified, this bill, a version of this bill was passed in 2023, passed out of the House. And there are changes between what is in front of us and what was passed in 2023. I could go over what all those changes are. But I think that the main one is this issue of fair market value versus net book value. So the bill talks about net book value. Am I right? I have that right? Yes. Yes. And the bill that was passed had fair market value as the standard for what was required. Still, or what they could pay. Using Federal Energy Regulatory Commission accounting methods, still relying on that body to determine what that is. But the net book value, and as Steve pointed out, I think this was a bone of contention in the hearing, and I think it certainly was in 2023. It got amended to fair market value. So I think that's the big difference. There are other differences. Some of them are updates of the bill, the references to the equipment, you know, which I don't know really, is any kind of a substantial difference. And I don't know, what else, Steve? Was there something else that was a major change? I think that's about it, right?
Who can work on it?
Oh, who can work on, yeah, we want to talk about that
But
too.
I would like to tee up the compensation piece and then ask some of the people on this call what's going on. So, okay. In general, fair market value is the price. I'm not using the legal terms here, but basically the price that a disinterested person would sell you something, right? They don't have anything to gain out of it, and what would that price be? That's the standard in eminent domain proceedings is fair market value. Net book value is an accounting concept that is basically the undepreciated value of an asset. So let me give you an example. An asset is usually depreciated. A long-term asset would be depreciated over its useful life, maybe 30 years. My house is a good example. My house is 30 years old. If it were on the books as a business, it would be fully depreciated at this point. However, I would not sell it to you for $0. I would sell it to you at fair market value, which is, ideally a couple $100,000, right? So that's the main that's the kind of the difference just between the two concepts normally. However, in the Pepco case related to this that was being referenced, the two groups have appeared to agree that in this case, selling streetlights, the fair market value equals the net book value. And that is when my brain decided to turn off slightly.
Well,
So
we
I would
have,
just like to throw it to a couple of these
okay,
groups
we
here. Like,
have,
what is going on
yeah, what the
with
heck is
this?
going on? So
And yeah.
we
Mhm.
have Ann Clace from Pepco on the call. Ann, could you comment on Steve? So
So
Steve's brain doesn't explode right
I
here
think
on live
so. I
stream.
think you are getting exactly to the point of this pattern. I honestly can't get to net book value and all of this. I think that's to the point. This is an ongoing case at the Public Service Commission. It's very complicated. There's a regulatory proceeding that has been negotiating this. We have come up with an agreed definition of what the streetlight should be sold for. This is the agreement in place that the municipalities and Pepco and have agreed upon. It's my understanding there is one more issue that needs to be discussed. And, we really do think that a piece of legislation is not necessary at this point, and we should just let the proceeding continue at the PSC right now. As you can tell, it's complicated, and we have been working together with the municipalities to really get to a resolution, and we feel like we're really, really close to where we need to be. So again, I mean, I can go and ask our attorneys to come in and talk about that definition specifically. I'm sure Sue Ellen is on the phone and can probably talk about the specifics of it, but to go and, create a new definition in statute in the law when we've already negotiated this whole thing and come up with a definition, we just don't think that's probably the best use of everybody's time right now.
Okay. I would ask that, thank you, Ann. I would ask that, when I ask you a question, like, that's not an invitation to testify. All right. That's an invitation to answer the question. So Sue Ellen, if you can answer the question. If you can't, we're going to continue the discussion. So can you answer the question about the fair market value and the book value being the same in the proceeding?
I can.
You cannot. Okay.
I can.
Oh, you can. I'm sorry. Go
Yeah.
ahead. I'm sorry.
I've been part of the negotiations of these model agreements from day one. And I can say, and I told Ann this earlier this week when we saw her in the hall, that we agree that net book value has been agreed between the parties, and that if I think the language that's in the bill right now is consistent with it, but if they want the verbatim of that language to be put in instead, we're agreeable.
Okay. Thank you. All right. I see that too. Let me ask a question of Ann though. Ann or Sue Ellen. Let me ask a question. So you mentioned in the hearing, Ann, maybe you had this answer. You mentioned in the hearing that the proceeding, there's going to be a ruling like July. Is that right? What was the date of the ruling that was going to?
So, David, you may have the exact date. So it's I think it's April. I think the municipalities asked that it would be rescheduled, right? So, I think
April
you're on
23rd.
vacation. So I think they asked for postponement.
Okay, so there should be a resolution of the case
April
in
23rd.
April. Is that what you're saying?
I think there's a new hearing that to
Okay.
go over one more item, the final item that I think needs to
Final
be
item.
addressed.
Okay, okay, and that's in April. Do you know the date of that, David?
April 23rd currently.
Okay, April 23rd. Okay. All right, thank you. All right, I see two committee members have their hands up. Delegate Naraki.
Thank you, Madam Chair. Two questions, if that's okay, Madam Chair.
Sure.
The first question is with respect to the ongoing case at the PSC. Is that just Pepco? Are there other parties to the case? I'm thinking about in Baltimore region, it's BG, it's a different operator. You know, I'm just trying to understand who is a part of that case that's going on at the PSC.
David?
Yeah, that case is specific to Pepco.
Pepco, okay. And that's the only case, that's the one case that's out there. There's not another case at BG&E or anything like that, right? Okay,
Not to my knowledge, no.
okay, good. You have another question,
Yeah,
Delegate?
I do know this one's probably maybe for Steve. Steve, let's just say the subcommittee and the committee decided to wait to see what happened there in that case. Couldn't we then presumably take that case and use that as a model to guide discussions for other jurisdictions like mine, where I'm thinking about BG and others? You know, I'm just I want to understand. I mean, we could do that, correct?
Yes, you could do that. This it would be a new General Assembly next year. But
Sure.
yes, the next General Assembly could do that.
Okay.
Yeah.
Thank you.
Yeah, the other thing we could do, Delegate Naraki, I assume, and this is for Steve also, is we could also draw a line around that and say that, you know, recognize that in the legislation that
That's
was.
a thought. No, okay, that's fair.
Yeah.
That also you got where my head was going with that, Madam
Yeah.
Chair. So thank
Yeah.
you.
Delegate Grammer?
Thank you, Madam Chair. I wanted to ask Ms. Clace, I'm new to the regulatory end of this. What happens if we pass the bill and there's some kind of ruling? What happens in that scenario?
And you can defer to David if you want to.
Well, or probably Steve. I do think this statute would probably overrule the ruling about Steve
Steve?
I mean,
Ross.
when it comes to rate cases, the timing of the filing can matter and how far along the proceeding is. I want to say that this is probably, and it depends on how close it is before the decision is made, or it also depends on the scope of the proceeding and whether or not it's like a full. I don't know the level that this is, this exact proceeding is off the top. I'm not sure. PSC would probably provide a better answer in this case. It sort of depends on, because this is not the first time there's been a law coming that would potentially affect the case, and there's litigation about whether it's retroactive or not, depending on how far along the case is, or it kind of just depends. It's not a black and white issue usually.
Okay, thank you.
And Anne, I think you held up a document like that's like a big document. Would you mind sharing that with us?
Yeah, happy to. This is the model purchase agreement, and the model
But that's
sales
not the
agreement.
ruling. That's not
No,
that's
this
not
is
the
the
official
agreement that
ruling.
we've been working on with the municipalities.
Okay,
I'm happy
okay.
to share some of the other documents as well that the
Okay,
commission
that
has
would-
ruled on.
Okay, that might be helpful because you said there's one issue that remains. What
Yes.
is that issue?
David can speak to
Yes.
that.
So the issue at its core is really around the requirement of a disconnect switch for after streetlight purchase ownership. So what the company stance and has always been is that the necessity of a disconnect switch is driven by the safety concern at play. And, there is several municipalities across the country. In Mr. Woodbury's testimony, he communicated a lot of the utilities that he'd worked in the Northeast. Several of those have engineering standards in place to require these disconnect switches. And so that really is the heart of the the
Okay.
last remaining issue.
That's the last remaining issue. Okay. All right, good. That gives us an idea.
Yeah.
Thank you. Anybody else have a question from the committee? Again, you know, as you can tell, this bill is certainly not ready for prime time yet, but I thought worth a discussion because it is complicated. So we asked Pepco for some information. Hopefully I know you will get it to us. You know, and as I said, we're not ready to act on this today. Does anybody have any more questions on this for today? Before we, well, that's really the last bill I wanted to discuss today, but I do have a couple of announcements. So anybody have any other questions for today? Okay, great. So we, you know, we're going to go back and take a look at this. And before we adjourn, I just want to talk briefly about HB 34, which we discussed last week. And, you know, that's the Mason's Law. Our discussion was pretty freewheeling, and I think that's because the bill's a little freewheeling. Where we are with that, and the reason we're not talking about it this week is because Kristen has been monitoring it on the Senate side, and we have been talking to some of the other stakeholders. We do not have amendments. We have reached out to MML and some other groups representing the municipalities and some other groups. We don't have specific amendments at this time, but the Senate is working on the bill. And Kristen, do you just want to update us, like kind of where it is in the Senate, or what you know about where it is?
I don't really have an official status, but from what I understand, that I know MML has shared their thoughts on concepts for amendments with, I believe, the Senate sponsor. The Senate sponsor has also been in touch. I have not had this conversation directly. It's a communication that's been made back to me. Been in touch with the Maryland Association of MAMSA, Municipal Stormwater Association.
Yeah.
And so that there are amendments being discussed. We just haven't seen anything finalized. And I know Delegate Foley and I had a conversation about just waiting to see what their starting point is and what's been talked about, because they have been working with some of the advocates directly.
Okay. Delegate Grammer, you have your hand raised.
Yeah, I had some ideas about liability. So the liability already is in place. It's common law. Anyone who, you know, any of these scenarios where a property owner, be it public or private, there already is liability in place. So I thought I had some eloquent ideas there, but that is already set in stone.
Yeah. Okay, good. I think we do have to like kind of narrow the scope of this bill, because otherwise we can run away with it. And then we either end up with nothing, you know, because it's too massive, or, you know, we end up with something that's unworkable that we can't pass. So I think we need to focus, and Kristen and I are working, and we're, like we said, she's in touch with the Senate. We're trying to figure out how to narrow this bill so that it has, you know, it's meaningful, but that it isn't so massive that it's impossible to implement. So just bear with us on that, okay? We're doing our best there. We'll get back to you on it, okay? In the meantime, Kristen did send out the information that we requested from her from last week. She sent it out at the beginning of the week. You should have gotten that. I forget specifically what that was, but it was
It basically it was taking some of the favorable with amendment
the testimony
and put it into context with the provisions that are in the bill.
Yeah.
Since there were a few different areas that testimony was addressing. So it was just trying to bring context to what was being asked and what part of the bill it would impact.
Right. So that's just for your information. Like I said, I think we're trying to get the bill so it's in a place where we can actually implement something. So that's all I have. Is there anything else from any of the committee members that we need to discuss today? At some point, we'll get to the point where we actually vote on some bills. We have a few easier ones that are coming, and then I have a bunch next week that are not going to be so easy, but that's all right. Anyway, anything else for the subcommittee before we adjourn? All right, I will entertain a motion to adjourn.
So moved.
Thank you. All right, I
Second.
will see you. Thank you, Ryan. So we're about to adjourn. See you tomorrow on the floor and